Tēnā koutou katoa, ko Steve Kerr toko ingoa. Hi everyone, I'm Steve Kerr. I'm a policy manager at the Department of Internal Affairs. And thanks very much for logging in and checking out this online presentation for the Modernising the Charities Act review consultation. We're about, at the moment, halfway through the process of having community meetings around the country. And we've had a lot of great discussions and good turnout at those meetings, but we know that a lot of people also aren't able to make it who would have liked to have attended. So this is a way to reach all of you that we couldn't meet in person. So I'm sure you'll find it really useful, and it's certainly going to be useful for us if we get your feedback in this process, because today this session and the whole process that we're doing is about hearing from charities and hearing from the public to help us do our job and to provide good advice to ministers on how to improve the Act. It's really the case that it's experience and expertise from people like you that counts in a consultation process like this. We can't just rely on Wellington bureaucrats like myself and lawyers and people here. We need to get out and hear from communities. So this is a way to reach all of you who couldn't attend in person. Just before we begin, a little bit about me and my role. I work for DIA's policy group. The policy group is leading this review process, and we're providing advice to ministers. So we meet regularly with the Minister for the Community and Voluntary Sector, Honourable Pini Henare. We talk to him about the issues that we're hearing at meetings, and ultimately we'll be providing some advice on changes to the Act or other changes. All decisions, of course, made by him as Minister and by the members of Cabinet. And we're here to listen and to provide advice. We in DIA's policy group are independent of Charities Services, which is the part of DIA that many of you will work with regularly, and you'll be familiar with them. So they essentially administer and run the Act. We're a different branch of DIA, and that separation between the two branches is important here. So why we're here, we want to hear your expertise, your experience, your views. As I say, the meetings have been really good so far. And we'll explain a little bit later about how to make a formal submission after towards the end of this presentation to contribute to the process. So charities play a really vital role in New Zealand and in our communities and in the country as a whole. Government can't do everything, and it shouldn't do everything. It's people and it's communities who are best placed to come together to solve problems and to create opportunities, and we're all really aware of that role that community organisations and charities play at the moment. So not-for-profit sector is one of the key ways that communities and people can come together, and registered charities are a really key part of that sector. A few facts and figures here on screen. There are 27,000 registered charities in New Zealand, give or take. So it's a really significant part of our lives and of the country, across all kinds of purposes and activities. So contributing to communities in all kinds of different ways. A total annual expenditure of around 17 billion. So actually, the charity sector, some people don't appreciate this, but it's a really major part of our economy and also a major part of our workforce. So there are about 180,000 paid staff, full-time and part-time, in the charities, working for charities in New Zealand, and nearly 250,000, 230,000 people were volunteering on a regular basis with charities. So it's such a major part of our society, of our economy, of our workforce, and that's why getting the legislation right and working as well as it can for charities is so important. So we want to ensure that the Act is supporting charities to deliver on their charitable purposes, that charities are able to inform policy and the sort of services that affect their communities. And we also want to make sure that New Zealanders understand and trust what charities do and have confidence in the system that assures that charities are kind of doing what they say they do. So that trust is important as well. The Charities Act itself, before we go on, it's worth just briefly talking a little bit about what the Charities Act does. I expect many of you won't have ever read the Charities Act, and that's fair enough. So it's essentially there to establish a registration system. So the purpose of the Act is to promote the effective use of charitable resources and to promote public trust and confidence in charities, and it's the register which is the main way that it does that. So it's a publicly available register. Obviously, you can go online, you can find out information about what charities do, financial information for any charity that's registered in New Zealand, all of those 27,000. So when you register as a charity, you're required to provide information to show that you have charitable purposes, and to regularly update that each year to show that you still meet the criteria. And there are compliance powers for the Charities Registration Board and Charity Services to make sure that the system is working as it should. And really the main idea here is that members of the public who are thinking of supporting a charity with their time, or with their energy, or through a donation, can have confidence in the integrity of the system and the credibility of the organisation that they're looking at. So the register was established in 2005 when the Act came into force. Initially, the system was run by the Charities Commission, which was established in 2005 and did all the initial registration of tens of thousands of charities. In 2012, the Charities Commission was disestablished, and its functions are now delivered by the Charities Registration Board and Charity Services, which is part of DIA. And in a minute or two, I'll talk a little bit more about how that works. So it's the Act which is the focus of this consultation, and hopefully you have already seen the discussion document that we have put out. If you haven't, you can access it on this page on DIA's website, dia.gov.nz/Charities Act. And it's the issues to do with the Act that we're setting out in the discussion document, which are really the focus of this consultation. However, as we go around the country, we're hearing it's a great opportunity for us to hear directly from people involved with charities, their experiences, and we are kind of taking on board some of that feedback as well. But our main focus is on the Act and how that's working. So what that means is we're not in a position to do anything about some of the issues which do affect charities day to day, things like funding, finding funding and sort of sustainability, or contracts and relationships with government agencies and local authorities. Those are issues that we know are important from the perspective of a charity, but they're a little outside scope for us in this process. And just speaking a little bit more about the process, we're in the middle of the public consultation phase at the moment. That ends with the deadline for submissions on the 30th of April. So if you get nothing else out of this presentation, I'd like you to remember that date and to make a submission to us. That can just be an email, or it can be as big as you like, depending on what you have to say. After the 30th of April, we will read and consider all the submissions that we get, and they'll help us develop policy. And we'll provide advice to the Minister, and Cabinet will make decisions at that point about any changes that might be required to the Act. And once those change to the Act requires legislation in the form of a bill. As that bill goes through Parliament, it will go to Select Committee. So the public will have another opportunity to feedback and have their say when the amendment bill is before Select Committee. So thinking about or looking at the discussion document itself, getting to the substance now, we have organised the key issues that we're aware of that we think people will have something to say about into 6 chapters, which are on screen at the moment. I don't try and cover every issue in the discussion document in this presentation. What I just want to do is try and give you a flavour of the key issues and some of the key questions that we're asking under each of these headings, so that you can so that you've got a bit of a heads up, and you can go in and read the discussion document, think about it, talk to your colleagues, talk to your friends, and make a submission. So I'm just going to run through these 1 to 6 now in the next few slides. We do ask some questions up front, which we don't have a slide for here, about the sort of opportunities and risks for the sector as a whole over the next 10 years, about people's vision for the sector and its role in our national life, and also on the sort of purpose of the Act. So there's some big picture questions up front in the discussion document, and then we turn to some more of the specifics here. Starting with obligations of charities. So what do we mean by obligations of charities? Well, a registered charity will receive certain benefits by being registered. So obviously the first one that springs to mind is probably the tax exemption and those tax benefits, but there are others too. Importantly, the kind of reputational status that goes along with being a charity, so that people know that you do what you say you do, that you're not for profit, and so on. And also there are quite a few funders and grant makers who will only fund registered charities. So in return for those benefits, a registered charity has certain obligations under the Act, and the key one that's front of mind for people is the filing annual returns with the financial statements and performance information. But you also need to notify charity services if you change key people in the organisation, or if you change the rules of the organisation, and so on. So there's a balance to strike here between having some rules to make sure the system is transparent and it's doing what it should, but that those rules are proportionate and aren't too burdensome for charities. So we want to know whether the current requirements on charities are reasonable, whether charities are having difficulties meeting those requirements, and whether there's enough support out there. And I think it's true to say that one of the key themes that's come out of the meetings that we've had so far is that a lot of small organisations at the Tier 4 level, so that's charities with with expenditure of under 125,000 a year, small charities are really struggling with the reporting requirements that have been introduced in the last few years. So that may resonate with some of you, and that's been a really clear theme so far. We also discuss in this chapter the idea of governance standards for charities. So that's kind of consistent requirements for how charities operate. At the moment in New Zealand, we don't have a single set of governance standards for charities. Depending on the legal structure of the organisation, whether it's an incorporated society or a trust or a company, there will be duties for key people in the organisation, but they're not always easy to find in one place. And in Australia, the approach they've taken is that charities have to meet core minimum governance standards, things like requiring a charity to remain charitable and to operate lawfully and to be run in an accountable and responsible way. So the standards there set out high-level principles, not prescriptive, precise kind of rules. So that gives charities some flexibility in terms of how they decide to comply with them. And so that's an interesting idea we're asking for feedback on. We want to know whether they could be adapted for New Zealand charities, and whether the idea of governance standards sounds like something that would add value for charities, or whether it would just be another layer of compliance. So we're keen to hear feedback on that. And then we also ask about the issue of accumulation of funds by charities, and this is something that the tax working group, which recently reported, looked into and has left for us to look at in the first instance. So we're seeking feedback on this. So some charities accumulate considerable funds or other assets in the course of their work. And obviously, in many cases, there are really good reasons for doing that, particularly thinking about charities who have an obligation and a duty to future generations. There's obviously a need to build up an asset base to continue to be able to support future generations. But in some cases, there are some cases of charities building up significant charitable funds where there's no clear kind of rationale about how those funds will eventually be spent towards their charitable purpose. So we're not talking here about building up a few $1,000s to renovate your meeting room or whatever. We're talking about kind of larger organisations with funds of many thousands or millions of dollars. Tax working group has asked us to look at this. In some countries, including Australia, there are sort of minimum distribution requirements for certain kinds of charities, not all charities. So would rules work like that in New Zealand, or would there be another way to address this issue? And is it a concern for you? Those are all kind of questions we're asking. The next chapter is about the role and functions of the charities regulator. So any legal regime, like the Charities Act, needs an agency that's responsible for making sure the overall system is healthy and the rules are being followed and so on. And we call that agency a regulator. In this case, in New Zealand at the moment, the regulator has two bodies. One is the Charities Registration Board, and that's a 3-person board whose members are appointed by the minister, and the board is required to act independently of the minister, and the law requires them to act independently. And it's there to make decisions to register or deregister charities. And then the other part of the regulator is charity services. And as I've said before, that's a unit within DIA, Department of Internal Affairs, and it does the day-to-day work of administering the charities regime. So it actually maintains the register and receives applications and does that sort of work. It provides support and advice to charities, resources on its website, and provides advice over the phone and so on. It also plays that compliance and enforcement role. It can do investigations and so on. It has powers there. And it also actually makes the vast majority of registration and deregistration decisions itself under delegation from the board, and sort of following the board's lead in terms of its decision making. And we've heard a lot of positive things about the way that charity services staff work and support charities at the meetings we've had so far, which is great. But we'd just like to know more about whether people feel the system is working well overall, whether the current setup with the board and with charity services is accessible, and whether it's accountable enough, whether charities have enough of a voice in the way that those bodies do their jobs. So in some countries, for example, there's kind of an advisory panel of representatives from the charity sector who have a role in supporting the regulator to do its job, and structures like that. So we ask about that in the discussion document too. Right. The next chapter is on the appeal mechanism, so to appeal decisions. This is something that is actually really fundamental to the overall to the Act and the overall regime, but it's something that most charities probably don't think too much about. So it's the reason the appeal mechanism is important is obviously, firstly, so that decisions can be appealed and decision makers can be held to account, and you need that in any statutory system like this. But it's even more important, or it's particularly important in the context of charities, because there's some really important parts of charities law that exist in case law. So a good example of that is the meaning of charitable purpose itself. It's not spelled out in the Act. It's in case law, and that case law needs to evolve and develop to reflect the way that our society is evolving and developing. And if you can't appeal decisions, then you don't get that evolution of the case law. So currently, board decisions to register and deregister can be appealed to the High Court under the Act, and appeals to the High Court. Appealing something to the High Court is costly and quite challenging for most people, most organisations. So since 2005, there have been 24 appeals heard under the Charities Act, as compared to about 56,000 registration decisions in that time. So we want to know from the public what body is the most appropriate to hear appeals. Is the High Court right? Or would something like a specialist tribunal, which exists in some in other countries, work better? And why? And what decisions under the Act should be subject to appeal? The next chapter is looking at Te Ao Māori and kaupapa Māori charities. So the Act needs to support the aspirations of Māori communities and iwi, and the Crown, through the Act, needs to be able to deliver on its obligations as a treaty partner. Kaupapa Māori charities are a significant part of the sector. They provide benefits not just to iwi, hapu, whānau, but to all New Zealanders. And we're talking about organisations ranging in size from small trusts running small marae trust right up to large iwi settlement organisations, and including some really well-known important major bodies like Kohanga Reo and Māori Women's Welfare League and so on. So we're just asking some pretty fundamental questions here. What in the Act is working well for Māori at the moment, and what's not? And we're interested in particular in whether the way that charitable status is interpreted is limiting in any way the activities of iwi settlement organisations that are registered charities. We've got two more chapters to go through. They're both quite interesting topics that have got a lot of attention. Firstly, charities and business. Firstly, we want to say charities need to raise funds to support their work. Obviously, they can't deliver without funds. And in New Zealand, business is an important way that a lot of charities do fundraising. And we're talking here, about what we're calling unrelated businesses. So that's charities operating businesses where the service or the product involved in the business doesn't directly contribute to the charitable purpose itself. And there's lots of examples of that: op shops, food and drink operators, food and drink companies, tourist operations, and things like that. So in some countries, charities are more restricted in terms of what they can do running businesses than they are in New Zealand, and there is some benefit to that because whenever charitable funds are put towards a business, there's some risk that those funds could be lost through the business trading. But on the other hand, it puts a big limit in those countries on on charities' ability to fundraise, because it could shut down the option of running businesses. So we want to test whether we've got that right in New Zealand. And lastly, charities and advocacy, another really interesting issue, and another one that's come through in the community meetings as a big concern. So we're talking here about advocacy in the sense of campaigning for a law change or a policy change. We're not talking about advocating on behalf of individual clients and supporting people. So advocacy can be a legitimate, really important way for charities to achieve their charitable purposes. And there's many really well-known historic examples of charities advocating for law changes. But the law and advocacy can be quite difficult at the moment for charities and the public to understand. And this means there's uncertainty for charities on the consequences of advocacy in some cases. They're not sure whether advocating on issues is always consistent with charitable purpose. And some of the big decisions, probably most obviously the Greenpeace Supreme Court decision, some of the big decisions in recent years have been to do with advocacy and charitable purpose. And we also know that charities are concerned about advocacy because they think it might affect their funding in some ways, or relationships with government agencies. And so that's part of it too. Overall, there's a concern that the climate could be limiting the effectiveness of charities in delivering their purposes, and also sort of limiting the quality of public debate in New Zealand on issues. So we want to know what the public thinks about this. Should charities have greater freedom to advocate for law change or policy change, or should there be limits on advocacy by charities? So that was a really quick run through some of the content in the discussion document. Really encourage you to have a look. We've tried to make it as accessible and easy to read as possible, even though some of these issues are quite technical and quite complex, but they're really critical to the sector and to the broader, to our broader country. Just a couple more slides on how to make a submission, how to have your say. As I said, you can access the discussion document and all the background papers, cabinet papers and so on at that URL there, dia.gov.nz/Charities Act. You may be viewing this seminar on that page at the moment, for all I know, so you're already there. Submissions are due on the 30th of April 2019. You can download a submission form and email it to us. You can just send us an email, post it in, whatever your preference is. And I'm just going to talk final slide here, just a little bit about making an effective submission too, because we don't want this to be a difficult or intimidating process for people to participate in. So just to really reiterate, it's your experience of these issues and your expertise as someone involved in an organisation that are really important and critical to us in this consultation and policy process. So give as much evidence as you can. Examples or case studies from your own experience are great. As much detail as you can, or be as clear as you can about the problems you're facing. Try not to assume that we know a lot about your organisation or about your circumstances. Give us the detail. There are a lot of questions in the discussion document, and it's just important to say you don't need to answer every question to make a submission, just the issues that are important to you where you feel you've got something to say. And then lastly, there are lots of good resources online to help make a submission. Tips and guidance. We mentioned one here which has been produced by Parliament on making a submission to a select committee. This is not a select committee process at the moment, but it's a public consultation, and the principles there are quite similar. One thing that people have asked at meetings a little bit is, if I make a submission together with another organisation, will it be somehow worth less because it's only one submission instead of two, if that makes sense? Or is this a numbers game? And the answer is no, it's not. We need to know who's making the submission, who's standing behind it, and if that's 10 organisations coming together. And if you tell us a little bit about your organisations and what you have to say, then we'll take that on its merits and on its own terms. It's not just a case of adding up the number of submissions on a certain point and in a really simplistic way. So if it works for you to come together with other similar organisations with views that you share, then by all means do it. Just explain who's making the submission. So this is the point in the presentation where usually I'll be asking for any questions from the public. So here I'm just going to run through a few questions which have been popping up quite a bit at the meetings, just to kind of to finish off this session. So firstly, quite a few people have asked about the way that this our consultation on the Charities Act fits with the review of the Incorporated Societies Act. So obviously a lot of registered charities are incorporated societies. So it's the it's MB, the Ministry of Business, Innovation and Enterprise, that are running the Incorporated Societies Act review process. There was a round of consultation a few years back on an exposure draft of the new Incorporated Societies Bill. So that legislation obviously dates right back to 1908. The exposure draft has been worked on, as we understand it, as a result of those consultation meetings, but as yet it hasn't gone back into Parliament to progress. So watch this space. MB will update on the progress of that work. We are certainly talking to MB and other agencies actually to do our best to make sure that legislation aligns as much as possible. We know that probably almost every charity is reporting through other statutory regimes as well. And where we can avoid duplication, we certainly seek to do that. Second common question is a good one. So why isn't this a first principles review? Why aren't you looking at key issues like charitable, like the definition of charitable purpose? There are a couple of reasons. It's a absolutely fair question and an important question. The government decided on the terms of reference for this process last year. And it decided at that point to look at all kinds of substantive issues in the Act, which I've just kind of run through, but not to go back and do a first principles review. And that was based partly on thinking about achieving some really positive change in a timely way, and that a first principles review going into charitable purpose and so on, it would be likely to take a long time. But also kind of the view is that the fundamentals of the Act are actually sound. So things like essentially having a public register, an accessible register, and having that kind of transparency and reporting requirements, that general setup is sound. We're certainly not hearing any complaints about the fundamentals of the Act, but we're interested to know whether it's all working within that framework, whether things are working as well as they can. Charitable purpose is an interesting one as well. Certainly, some countries, Australia and England and Wales, have spelled out charitable purpose in their legislation in a way that we don't here. The advantage of what we've got at the moment in the Act, so the Act essentially says that charitable purpose means charitable purpose as defined in case law. That is adaptable. It can keep changing over time through court decisions, but we are obviously asking questions about the appeal process to make sure that it is evolving as well as it should. And we're also keen to hear whether there's more that can be done to help charities understand the way charitable purpose applies in certain areas through guidance or similar. Third question. A lot of questions about the reporting standards for smaller charities, people struggling with that, and are there plans to introduce a lower standard or an easier standard for reporting for small charities? So I suppose the first point to make is that we don't have plans on any of this at this stage. It's a listening exercise at this point, but certainly, as I indicated before, it's been a really consistent theme that for a lot of small charities, the Tier 4 standards are too high. So we're keen to hear more about the way that impacts different organisations and how widespread those concerns are, and we'll build that into our recommendations as a result of this consultation. And we're talking to the External Reporting Board too. And that's the public body which is responsible for the reporting standards. They're due to do a post-implementation review soon on the reporting standards in the next few years. So we'll be taking the feedback that we get out of this process and passing it on to the relevant decision makers. Question 4. People are interested to know what feedback they'll get from this process, whether they'll know that their voices have been heard and what issues have been raised through the consultation process. How do we know we've been listened to? Those kind of questions, which are also really, really good questions. So we have started to summarize some of the key themes coming from community meetings on our website, so that people can see the kind of themes that have come up before. The public submissions that we receive after, due by the 30th of April, will also go up online, and we'll do a summary of those submissions. So you'll be able to see what's been said. We've also, right throughout this process, been proactively releasing cabinet papers, and we'll continue to do that. In fact, government's doing that with all its cabinet papers now. There's sometimes some redactions under the OIA, but we're running as transparent a process as possible. Question 5. Frequently asked question 5. People are interested to know about the idea that the regulator, Charity Services, might be given additional powers as a result of this consultation and as a result of the process. So there is a page in the discussion document which sets out some additional powers. I think it's about page 31, where Charity Services is running an investigation, to require information or to kind of freeze assets while the investigation's ongoing. So those are part of the consultation. Decisions haven't been made yet. Sort of similar answer to the question before. We want to know from charities and from the public whether they think those where any additional powers would be a good thing, what risks might come alongside that. The the ideas that are discussed in the discussion document there, they're based on powers that overseas regulators have. They're not just pulled out of thin air, but certainly the government wouldn't take a decision to give the regulator additional powers lightly. There are plenty of checks and balances there, and we know that there are other ways that, for example, criminal conduct or fraud can be addressed through other ways. So there's a lot of work and thinking to do in that space. But yeah, we're keen to hear your views. And last question that's come up quite a bit is around business. I suppose not a specific question, but just a bit of concern here. People are concerned that we're talking about charities and business. Are we going to sort of clamp down and stop charities running businesses or anything like that? And again, we haven't. We haven't made decisions on any of this, but that's not the intention here. And I think if you look at the discussion document, you'll see that we, absolutely acknowledge and understand that business trading is a really important source of income for some charities, and obviously charities need to raise funds. So the questions are really around the transparency of reporting, and whether that's sort of sufficient at the moment, because in some cases you'll have very you have group structures with a number of entities and money flowing between them, reporting in consolidated accounts. So it's that's a question for the accountants and lawyers as much as anyone. And really it goes back to how the regime and the regulator can best deal with the risk associated with business activity. The risk that funds, charitable funds, put into a business, and then that business fails or loses those funds, and the charitable funds are lost. So that's something that needs to be managed, but isn't sort of a deal breaker. So those are the questions we're asking on businesses. I'm going to wrap up there. I don't know how long it's been, but it feels like it's been quite a while. We've covered a lot of territory. So thanks again for listening. We are keen, we're happy to take questions from people watching this seminar online. You can email us at charitiesAct@dia.gov.nz, and we'll try and we'll get back to you all within a week and put those answers online too. And that way we hope that everyone's getting a fair crack at asking questions and raising issues or concerns or questions about the process. So yeah, thanks again for your time. Don't forget, make a submission by the 30th of April, and any questions for us about this presentation or anything to do with the process, drop us an email, charitiesAct@dia.gov.nz, and have a great day. Thank you.